hello to all my dear students. I hope your studies are going well. And in today's one short revision, I have come up with this chapter. Obviously, you can see it behind me. Limited Liability Partnership, applicable to both CAinter and CA Foundation. Whatever is applicable for CA Foundation, I'll tell you then and there that this is what is applicable for CA Foundation. The rest, everything is obviously applicable even for CAinter. So, starting with an LLP. LLP is a form of partnership, but one of the most unique feature of LLP is it is a partnership. But in case of partnership, we have unlimited liability, whereas LLP comes up with the concept of limited liability. Another great feature of an LLP is that when in the case of partnership, if a partner is dead, it results in the dissolution of the firm. But in case of LLP, if a partner is dead, it does not result in the death of the LLP. That means what? It has perpetual succession. LLP is one form of business where we have taken up features from partnership, we have taken up features from Companies Act, and together we have put them and have come up with this structure of business. So we can say that LLP is a hybrid of partnership and company. When we talk about LLP, it's a hybrid of, but you will see it's more similar to a company rather than to a partnership firm. In partnership firm, we have unlimited liability of the partners for the act of other partners also. But in LLP, partner's liability is limited, and even if a partner has done anything wrong, he will be liable personally. But the other partners will not be liable personally for his wrongful acts. Now, the next thing that comes up here is, in any case, will the Partnership Act apply on LLP? Absolutely no. Partnership Act nowhere shall apply on LLP. However, there are few references made to Companies Act. And whenever a reference is made to Companies Act, in that particular case, Companies Act will apply. So let's start with the LLP, the concept of LLP. Obviously, LLP is a partnership, it's like a partnership firm. It's a body corporate, which is a partnership form of business. So we have partners here. Now the question that arises here is that can the partner or should the partner only be a real person, or can the partner even be an artificial person? A partner can even be an artificial person. So when I talk about partner can be a body corporate or partner can be an individual. So even a company, can two companies put together form a partnership, LLP? Yes, they can form an LLP. So even obviously their MOA should allow that they can enter into a LLP as a partner. Their MOA should allow, but can they? Yes. So when we talk about partners of an LLP, it could be individuals also, it could be body corporate also. So when I say individuals means you and I. What is body corporate? Now when we talk about the term body corporate, the term body corporate has not been defined under the LLP Act. So they say, please take the definition from Companies Act. Now what Companies Act says is, body corporate means a company and includes a company incorporated outside India or an LLP incorporated in or outside India, but does not include a corporation sole, it's a single person office, or a cooperative society, or now they have given this power to the central government. That look, central government, if tomorrow you feel like declaring that this body corporate will not be considered as a body corporate from today onwards, you can actually notify in the official gazette, and from now on it will not be considered as a body corporate. But even central government power is restricted. A company and an LLP incorporated in India is always a body corporate. So in no way can the central government notify that a company is not a body corporate. So can they say Reliance is not a body corporate? No, that is for sure, for life it will be a body corporate. So a company and an LLP incorporated in India is always a body corporate. So I repeat again, who can be a partner of an LLP, an individual or a body corporate? What is a body corporate? Body corporate means a company. A company obviously means incorporated in India and includes a company incorporated outside India, LLP incorporated in India or outside India, but does not include a corporation sole, it's a single person office, or a cooperative society as which has been incorporated under the Cooperative Societies Act, or any other body corporate which the central government may notify. So on this, tell me, can an individual be a partner in an LLP? Yes. Individual can be an Indian resident, foreign resident, Indian citizen, foreign citizen, anyone. Right? Anyone. Now my second question is, tell me, can a company become a partner of an LLP? Yes. Third question is, can a company incorporated outside India be a partner of an LLP? Yes. Now, next is, can an LLP incorporated in India be a partner of an LLP? Yes. LLP incorporated outside India, can it be a partner of an LLP? Yes. And my last question, can a foreign company be a partner of an LLP? Yes. So, all of them can, but can a corporation soul or can a cooperative society be a partner? No, they cannot be a partner. Why? Because they are not included in the definition of body corporate, and a body corporate can be a partner of an LLP. I hope this is clear to everyone. Yes, so I hope this is clear to everyone. Now, an individual is disqualified. Disqualified means you cannot become a partner of an LLP in these three cases. First case is if he is declared of an unsound mind by a court of a competent jurisdiction and the finding is in force. That means a court which has the right, jurisdiction means the power to take up the case or to power to pass such an order. A court has a jurisdiction to declare a person unsound, and that court has declared a person as an unsound person. So when he is declared as an unsound person, he is disqualified to become a partner. Second, he has applied to the court. See, in some cases, the moment you apply to the court, you are disqualified. In some cases, only when the court declares you insolvent, you are disqualified. If you remember partnership, only when the court declares you insolvent, you are disqualified. Here, the moment you apply to the court to be declared insolvent, you are disqualified. Then if he is an undischarged insolvent, what is this undischarged insolvent? It's the period from the day the court declares you insolvent to the day your liabilities are what? Paid off. That period of time, that period between the court declaring you insolvent and your liabilities being paid off, that period you are an undischarged insolvent. I hope it's clear to everyone. Now when I talk about, now for those who are wondering where will I find this document, in the link I have given the link of a channel, Telegram channel. If you go to that channel, you will find this document. And this is applicable, this chapter is applicable for CA, CMA, both foundation, inter. Now moving forward, what is the minimum and the maximum number of partners? The minimum number of partners is 2, maximum is unlimited. So minimum comes from private company or partnership, maximum comes from public company. Maximum is unlimited. So there is no limit to the maximum number of partners. However, can the number in any case fall below 2? It may happen, but minimum 2 is always required, but it can happen that it falls below 2. Any reason, partner left, partner died, whatever. In that situation, you are given a period of 6 months to bring back the number to 2. You are given a period of 6 months. Within this 6 months period, you should bring back the number to 2. If you don't bring back the number to 2 within this 6 months and you still continue the business, then after 6 months, whatever you do, that single partner will personally be liable. So, if the number of partners is reduced below 2, so I'm not telling you please bring the number. So let's say A and B were partners, B is dead, A alone is left. B is dead, let's say on 10/1/2024. We are not telling you do it immediately. We are giving you 6 months period. We are giving you from 10, we are giving you 6 months. Within 6 months, please bring back the number to 2. Let's say on 10th of August, the LLP contracts with T, but the LLP fails to pay T. Can T sue A to recover the money? Yes. So, if the number of members is reduced below 2 and the LLP carries its business for more than 6 months with the reduced number, then the only partner A who has the knowledge shall be liable personally for the obligations during that period. What is this during that period? During that period here means after the end of 6 months. In this 6 months period, you are not liable. But after 6 months, if any contract is made, then you become personally liable for that. I hope this is clear to everyone. So I repeat again, who can be the partners of an LLP? An individual or a body corporate. What do you mean by a body corporate? It means a company including a foreign company, including a company incorporated outside India, LLP in or outside India, but does not include a corporation, sole or a cooperative society or any body corporate notified by the central government in the official gazette, not being a company or an LLP. When is an individual disqualified? If he is declared to be of an unsound mind by a court of jurisdiction, competent jurisdiction, and the finding is enforced, he is an undischarged insolvent or applied to the court to be declared insolvent. What is the minimum and maximum number of partners? Minimum is 2, maximum is unlimited. If at any given point of time the maximum number falls below, falls below 2, then in that case you are given a period of 6 months to bring back the number to 2. If you fail to do that, then if you carry the business after 6 months, you will become personally liable for whatever the LLP does. Till this point, I hope it's clear to everyone. Now, see, LLP is an artificial person. The people who are managing, the people who are the partners of the LLP are also artificial person, body corporate. Everyone is artificial and there are unlimited number of members, right? Maybe some are not even competent to carry the business. We are just taking them for the capital that they can bring in. So many people, too many cooks spoil the broth. If no one is given any authority or duty or obligation, blame game will also happen. So to avoid all of this, we have this concept of designated partner. The business will be carried by them. All the legal findings and everything shall be done by these designated partners. So who are these designated partners? Directors, you remember, a little similar to that. Designated partners, how many should we have? At least 2. Now they have said at least 2. Can I have more than 2? Yes. But minimum 2 is mandatory. More than 2 is your choice. Now when I say designated partner, okay, when I say designated partner, can the designated partners be artificial person? Wow. It would be like a vicious cycle. First, my LLP is an artificial person, my partner is artificial, designated partner is also artificial. So to manage the designated partner, I need someone else. Imagine. So please understand the designated partners cannot be artificial people, they have to be individuals. Now, if all my partners are individuals, any 2 partners can become the designated partner. If all my partners are body corporates, so these bodies corporate, they will send nominees. Any 2 nominees can become the designated partners. And if I have my partners are a combination of individuals and body corporate, then any 2 individual nominee, anyone can become the designated partner. So, any 2 can become the designated partners, of which at least 1 should be a resident of India. What is the concept of resident of India? Who has stayed in India for at least 120 days during the financial year. During the financial year, you have stayed, please understand, every act has its own definition of resident of India. In income tax, 182 days or more. In in FEMA, more than 182 days. In OPC, it is 120 days in the immediately preceding financial year. Here it is 120 days during the financial year. Right? Now, this designated partner shall be responsible for all the acts and liable for the penalties. So, whatever the filings, whatever act has to be done by the LLP, who will do it on behalf of the LLP? The designated partner. Now, first of all, the designated partner will give the name of the incorporation document will give the name of the designated partner, that these are designated partner. And if it says from time to time everyone will be a designated partner, that is, we are going for a rotation. First year these 2 people, next year these 2 people. In that case, every partner will be considered as a designated partner. Correct? Before I appoint you as a designated partner, I need to take your prior consent. That okay, I am agreeing to become a designated partner. If you want to become a designated partner, you must hold a DPIN, designated partner identification number. For directors, we have DIN. Here we have DPIN. Provisions of section 153 to 159 lays down the provision of how you can get a DIN and everything. If you want to cancel it also, surrender, everything is given in this section. The same will apply even for DPIN. Mutatis mutandis. That means there you will apply for DIN. If you want to apply for DPIN, same procedure, but instead of DIN, you are applying for DPIN. Right? And if you want to act as a designated partner, you must have a DPIN. Only then you can act as a designated partner. And within 40 days of your appointment, the LLP will file all the details of your, your name, address, all those details, all the particulars will be filed with the registrar. So see, incorporation document will give the name of the designated partner. We must take the prior consent of the designated partners within 30 days of appointment. Particulars will be filed with the registrar. He will obtain a DPIN. If there is a vacancy, what is this vacancy? He resigned, he left, he left the LLP, or he is dead, whatever, he faces any of the disqualifications, it's a vacancy. Within 30 days, we have to fill up the vacancy. So the vacancy will also be filled up within how many days? 30 days. So I repeat again, I hope everyone is clear about the designated partner concept. In this vacancy, so we have two designated partners, no? So during this vacancy, the one who is left will be acting till the other one is not appointed. Okay? Can I go forward, guys? I hope till this point it's clear to everyone. Yes? So moving on to the next part, incorporation of an LLP. This is a shorter version of Section 7 of Companies Act. You will see the procedure is almost the same, but little shorter version of the same. Incorporation, first of all, I need 2 or more persons who will sign the incorporation document. They will have to reserve the name in RUN LLP, and this name is available for a period of 3 months. That means the day the registrar says yes, this name is available, you have 3 months period to register yourself with that name. We have to, just like company, here also we have to hire a professional. So whenever we are incorporating an LLP, we will hire a professional who is going to guide us through the procedure. So this professional who we have hired, he will give a statement, and with him one of the persons who have signed, that is who would become the directors, they will give a declaration. What declaration? A statement that whatever was needed to be done under the act or the rules, we have followed everything. So see here, 2 or more persons will sign the incorporation document. They will reserve the name in RUN LLP. A statement shall be given by any professional. Who is this professional? Advocate, CS, CS or CMA in practice, who has signed, and by one of the persons who has signed the incorporation document that we have fulfilled all the requirements of the act. Incorporation document shall also state, I'm not going slow because it becomes too sluggish, then you've already done the chapter, here it's just revising. Let's say even if you have not done the chapter, you just watch this video, it will be more than enough for you, you will still be able to answer everything. So the incorporation document will also state the name of the LLP, the address of the LLP, the proposed business of the LLP, the name and address of the partners, name and address of the designated partners, and any other information which is required. One thing here, tell me, when I talk about partners, if the LLP has only 2 partners, can I say in that case these 2 partners will also be the designated partners? But if we have more than 2, then any 2 can be the designated partner. We will file it with the registrar of the state. So if I want to get incorporated in this city of Kolkata, I will file it with the registrar of West Bengal. Within 14 days, he will issue a certificate of incorporation under his hand and under his seal. And this certificate of incorporation is the conclusive evidence of incorporation. That means no one can question it. Once I have got the certificate of incorporation, within 30 days of incorporation, I will make a LLP agreement and file it with registrar. Please understand, from incorporation, within 30 days, okay, I should have a LLP agreement and I will file it within 30 days. But please understand, 30 days is not from here. 30 days from incorporation only I should file it with the registrar. So please, 30 days of incorporation, file the LLP agreement with the registrar. So you are not getting 30 plus 30. Okay, within 30 days of incorporation only. If it is incorporated by giving false information, then we have imprisonment up to 2 years and fine which is not less than 10,000 but can go up to 5 lakh rupees. This fine, if you can remember, it would be good. So moving on to the next concept, small LLP. So what happens if you are a small LLP? You enjoy certain privileges. So please, when I talk about small LLP, because you've already done small company, try to compare it with small company. In small company, we have paid up capital limit and we have turnover limit, right? Same here also, but here do we have paid up capital? No, we only have contribution. Now, what do I mean by contribution? Contribution means whatever capital is introduced by the partner. Now, this could be monetary or it could be in kind, in the form of property. Property can be movable, immovable, tangible, intangible, anything. So here, instead of paid up capital, please, there we have paid up capital. Here we don't have paid up capital because we don't issue shares. Here we have partners contribution. So partners contribution should not exceed 25 lakh. And turnover, here also we have turnover. But there we have PL. LLP does not prepare a PL. But LLP prepares a statement of accounts and solvency. So turnover as per the statement of accounts and solvency of the immediately preceding financial year should not exceed 40 lakh. If these two conditions are fulfilled, you are a small company. Now what do I mean by financial year? What do I mean by financial year? Financial year is a period which starts on the 1st of April, ends on 31st of March. But if my company, if my LLP is incorporated after 30th September, so let us say my LLP is incorporated on 1st October 23. So financial year will be 1st October 23 to 31st March 24, no, 25. See, if it is incorporated after 30th September, then in that case 31st March of the year next following that year. Year next following that year. Correct? Now, if my LLP is incorporated on 30th September 23, then it would be 31st March 25 or 24? 24, not 25. That means on this, the maximum period of financial year for an LLP can be up to 18 months, right? Can be up to 18 months. I hope this is clear to everyone. Can I move forward, guys? Yes. So moving on to the next concept, registered office. Now, can an LLP survive without a registered office? Obviously no. Every LLP must have a registered office. I want to send some notice. I want to send any letter, any document, any communication. Anything that I want to send will be sent where? To the registered office. How will it be sent? It will be sent, law very specifically says, if you want to send any document, send it by post under a certificate of posting, or send it by registered post or any other manner as may be prescribed. Can I change my office? Yes. If I change my office, I have to file it with the registrar, and the change is valid only after such filing is done. The next one, name. Can I say, obviously, I am born, I cannot survive without, oh my god, which LLP is it? Acha, LLP 1, LLP 2. We cannot name LLPs like that. We don't know which is 1, which is 2, and how would we identify one LLP from the other? So every LLP should have a name. The name of every LLP should end with the words LLP so that I know this is an LLP, right? So it should end with the words LLP. Now the name cannot be undesirable. What is undesirable? Using names which are not allowed, which are prohibited, showing a connection to the government, and it should not be resembling or identical or very similar. See, I've used the word similar or identical or resembling. I did not say same. So phonetical resemblance, spelling, COLOR, COLOU are not allowed. So it should not resemble the name of any company or LLP or registered trademark. What is registered trademark? I've already discussed all that in the class in details. Don't want to go into all that right now because there is no point here. So it should not resemble the name of any of this. Okay, so I said it should not resemble. Okay, so ma'am, I'll sit and Google. Arey Babba, you will be lost in that only. You don't have to sit and Google. Please make an application to the registrar. I want this name. Is it available or not? Registrar will tell you is the name available or not. So you don't have to do all this. If the registrar says this name is available, the name will be available to you for a period of 3 months. Within 3 months, please register yourself with that name, or if you want to change the name to that name. If you don't do that, then after 3 months the name is not available. If you want that name, you'll have to reapply again. What happens if the name is identical? By mistake, by inadvertence, the name is identical. Now, how can it be identical? I asked the registrar, to err is human. No, maybe he thought name is available, but actually it's not available. In that case, do you think the old LLP or the old company or the owner of the trademark will sit and cry, oh, name identical? No. They can go and make an application to the central government that please the name is identical, ask the new LLP to change the name. Who can make the application? The company, the old company with whom the name is identical, the old LLP with whom the name is identical, or the owner of the trademark. they can make an application to the central government. Please ask this LLP to change the name. Please ask this LLP to change the name. Now when I say proprietor, if the proprietor is making an application, this application should be made within a period of 3 years. That means what? Here the LLP was incorporated with a name which is similar to a trademark. So within 3 years the application should be made. If not made, the proprietor cannot make an application to change the name. So let us say in 2010 I got a trademark registered. In 2014 LLP was formed using my trademark, little similar to my trademark, whatever. So I can only make an application till 2017, that is 3 years. I want to make an application in 2018, can I do so? No. If the name resembles a company, can the company make an application in 2018? Yes, for a company or an LLP there is no time limit. But if a proprietor, that is owner of a trademark, he wants to make an application, he can only make an application within a period of 3 years. When such an application is made, the central government will order the LLP to change the name. Within 3 months, the LLP must change its name. Once the name is changed, within 15 days, you should file the order. Which order? Central government order and a notice of the change to the registrar. Now, registrar had given you the certificate of incorporation with the old name. He will make the changes in the certificate of incorporation and give you the new certificate of incorporation with the new name. Once he gives you the certificate of incorporation, within 30 days, please change the name in the LLP agreement. Within 30 days from the date he gives you the certificate of incorporation, make the changes in your LLP agreement. What happens if the LLP defaults in changing the name? If the LLP defaults in changing the name, central government will allot a new name on its own. The registrar will make the name, enter the name in his register and issue a certificate of incorporation. Can the LLP change this name allotted by the central government? Yes, that you can do. But otherwise, central government will allot you a new name. I hope till this point it is clear to everyone. For foundation students, this is the last topic that is there in your syllabus, and the rest of the act is not there in your syllabus. Please don't forget to do the differences and the characteristics, because for the foundation students even that portion is quite important. Right? Now we'll continue with the rest of the portion, which is applicable only for the inter students. Now, what will be the mutual rights and liabilities of the partners? Who will share what? Who will be liable for what? All this, where is it given? It is given in the agreement. So the mutual rights and liabilities will be governed by an agreement between the partners. If there is no agreement, in that case, the act in the first schedule, of the act, all the terms are given and we will adopt those terms. Right? Can I change this agreement? Yes. And if you change the agreement again, it should be filed with the registrar. Let us say partners have made a contract before incorporation of LLP. Okay. This contract was made before incorporation of LLP. So can we say it's a pre-incorporation contract? Yes. Now the question is the LLP liable for this contract after incorporation? After incorporation, if all the partners ratify it, if all the partners ratify this contract, the LLP is liable. So any contract made before the incorporation of the LLP between the persons who have subscribed their names to the incorporation document, that is to the would-be partners, shall impose an obligation on the LLP provided such agreement is ratified by them after the incorporation of the LLP. So, can a partner, after he is joined, is it that I am partner for life or can I actually leave partnership? We can. So, termination of partnership can happen. So, what is cessation? It's basically termination. It can be by choice or by default. By choice is, there is an agreement between the partners that on this day I will leave the firm. And if there is no agreement, then I can give a notice, a written notice and leave. But I have to give a 30 days notice. In partnership, there was no such concept of period of notice, right? In a partnership there was no such concept of period of notice. Here we have a 30 days notice. Just a second. Now it can also happen that by default a person may leave the LLP. By default, death, you've become insolvent, you've become unsound, the LLP is only dissolved. How can you be a partner? Now when you leave the firm, should you give notice or not? Yes, you have to give notice. Now let's say A was a partner of an LLP. Okay, A was a partner of an LLP and he leaves the firm. But notice was not given to the ROC. B, not knowing that A is no longer a partner, contracts with A on behalf in the name of LLP. Like A contracts in the name of LLP. Is the LLP bound? Yes. A will be deemed to be a partner. Now let's take another case. No notice was given to the registrar. Okay. But B knows that A is not a partner. B knows A is not a partner. So is LLP liable? No. Even the notice was not given to the registrar, B knowing about this fact, not being ignorant about it, cannot hold the LLP liable. Let's take third case. A has left the LLP and notice was given to the registrar that he is no longer a partner. B was unaware, makes a contract. Is the LLP liable? No. You have given notice, third party doesn't know, no liability. So, he shall be deemed to be a partner if the person has no notice or notice was not delivered to the registrar. When a partner leaves the firm, what is his rights? He will get his capital contribution. He will get his accumulated profits after deducting accumulated losses. But just because he has left the firm doesn't mean that he has no future, he will not have any obligations for the acts done while he was a partner. So as a partner, whatever was done, he shall continue to be liable. But after he leaves the firm, there is no obligation, neither can he for future acts, nor can he now take part in the management of the business. If a partner is dead, in that case, all these rights will go to the legal heirs. Now, when a partner leaves the firm or a partner becomes a partner, a person becomes a partner or a partner leaves the firm, don't you think the LLP should inform the registrar? Yes. The LLP should within 30 days inform the registrar. Again, let's say a partner of an LLP was a very, very normal guy, but in LLP he joined and the LLP was doing great. He earned a lot of profit, so he bought a new house. Now he has shifted to his new house. So you remember in incorporation document I had to give my name and address, so that address has changed. Should I inform that change of address or not? Yes. So if there is a change in the name or address of the partner, he should within 15 days of the change inform LLP. LLP will in turn within 30 days of change, please understand, not 15 plus 30, no. Within 15 days of change, we will inform the LLP. Within 30 days of change, LLP will inform the registrar. Right? If, let's say I am no longer a partner, I fought with my other partners because they were doing wrong activities. I was like, I'm not going to continue in your firm. I'm sorry, I'm leaving. Bye bye, Tata. He left. So when that partner left, the other partners must have given notice. But the other partners were so angry, they did not give notice. They were like, oh my God, wait, we will not leave you. They did not give a notice. Can he himself go and give notice? Yes. So, if the partner has reasonable cause to believe that the LLP may not file notice, he may himself file the notice to the registrar. But see, can I just depend on what the partner says and make a change? No. Maybe he was the one who was doing fraud and he is still a partner, but he is saying that I am not a partner. Registrar will confirm from the LLP, and if within 15 days there is no objection or confirmation, he will make the changes. I hope this is clear to everyone. Can we go forward? Yes. Now, the concept of partnership is partner is an agent of the other partners. Here, partner is an agent of the LLP, but he is not the agent of the other partners. So, if a partner does anything wrong, he is personally liable, but the other partners are not personally liable. So see here, first of all, he is an agent of the LLP but not the other partners. If the partner does any act for which he has no authority to do, and the third party knows that he has no authority to do the act, then will the LLP be bound? No. So I am contracting with you. It is not my authority to make the contract. You also know this is not my authority. Can you hold the LLP liable? No. In case for any act that I have done within my authority, is the LLP liable? Yes. And LLP liable means it's the sole obligation of the LLP. Partner is not personally liable for the obligations of the LLP. He is personally liable for his wrongful acts, but not the wrongful acts of the other partners. Correct? Now, what is partners by holding out? You've already done this in partnership also. I am not a partner of the firm. The partner of the firm takes me with him and represents me as a partner to the third party. And I should have clearly said, wait, I am not a partner. But did I do that? No. I agree I am a partner. Or I only go and tell everyone, you know, I am a partner of this LLP, I am a partner. I am not a partner, but I say. So either a partner represents me as a partner, or I myself go and represent myself as a partner. In any of these two cases, I become a partner by estoppel or holding out. And now if the LLP contracts with the third party, that is on the faith of this representation, if the third party gives any credit to the LLP, I am also liable. Personally, I am also liable. So, if a person by his words or by his actions represents himself or knowingly permits himself to be represented as a partner, even though he is not a partner, then in that case, such person shall be liable to every person who on the faith of such representation has given credit to the LLP. Right? Now, let's say one partner is dead, ABCD LLP. Okay, D is dead, but they carry the business with the name of ABCD LLP only. They don't change the name. Will D's legal heirs or his estate be liable for the future acts? No. So, on the death of a partner, the firm continues with the old name. Such use shall not make the legal heirs or the estate liable. Shall not make the legal heirs or the estate liable. I hope it's clear to everyone. Can we move to the next section? The next section is all about fraud. So, moving on to the next section now. Now, the concept of LLP is limited liability. But you only tell me logically, if fraud is being done, do you think the liability will be limited? Obviously not. Obviously not. So when we talk about fraud, what is basically fraud? What all acts will be considered as fraud? When we have done any act to cheat the creditors or to cheat any other person or any fraudulent purpose, that is considered as fraud. In that case, who is liable? The LLP and the partners will have unlimited liability. Which partners? All partners? No, only those partners who have participated in that fraud. Because if you remember, LLP partners are the agents of the LLP, not the other partners. So I am not liable for the wrongful act of the other partner. Now, LLP is not liable if the LLP proves that the act was done without the authority of the LLP. Now, here, in case they have done any fraud, they are also liable to compensate the person who has suffered any loss. Whistle blowing, please don't start blowing the whistle. We are not talking about that. Whistle blowing here means basically bringing to the knowledge of the authorities any wrong which is happening. So let us say there are 5 partners and they have done some fraud. All of them has done some fraud and an investigation is going on. The other 4 partners are like, dekh lenge, hoga, jaise hoga, dekh lenge, kar lenge, that types. This one partner, he was like, oh my God, now they will take me to the jail. They will take me, punish me. I don't have money. What will happen to my kids? What will happen to my family? He is like, no. He goes to the other, to the investigating authority and tells them, look, I will give you all the information that you want. Right? I will give you all the information that you want. But you have to please give me some relief. Right? So you must have watched in movies, no, you become the state witness, we'll make sure you're not punished. Right? Something like that only. So I am telling, I am a part of the wrong. I have done that wrong, but now I am telling, I will give you evidence of the wrong, you please don't punish me or reduce my punishment. So the court may, this is our court actually, the court may reduce or waive. Reduce means to lessen, waive means to give up. the penalty which is leviable if the partner or employee has provided useful information, or because he has provided information, this leads us to punish the LLP or the partner or employee. So his punishment will either be reduced or it will be waived off if he gives information, or because he gave the information we were able to punish the LLP or the partner or the employees. Now, when I have already discussed this concept of contribution, what exactly is a contribution? It is what I bring into the LLP. It could be in the form of money, it could be in the form of goods, movable, immovable, it could be in the form of service, it could be tangible, intangible, anything. Service, I am a computer software, I am too good at it, so I'll do the software servicing part. So that is also a contribution on my part. Contribution can be monetary, and when the contribution is made in kind, how will you account it in the books? You will actually calculate the monetary value of the contribution, and that will be accounted for. Right? You will actually calculate the monetary value and that will be accounted for. Right? Now, let us say each of the partners had to bring in a contribution of 10 lakh. But partner A was in a very bad situation. So he tells his partners, I cannot bring 10 lakh, I will only bring 4 lakh. Others say okay. There was a third party, Mr. T. Okay, there was a third party, Mr. T, who knows that A's contribution is 10 lakh, and on this basis he gives a loan to the LLP, not knowing that the contribution has been reduced to 4 lakh. I repeat again, every partner had to bring in 10 lakh, but A's position was bad. He says, I'll only bring 4 lakh. Others agree. T, a third party, not knowing about this, gives a loan to the LLP. He only knows that he will bring how much contribution? 10 lakh. He doesn't know that it's reduced to 4 lakh. Can he force A? Can he enforce against A a contribution of 10 lakh? Yes. See, if a creditor extends credit relying on the obligation, if the creditor extends credit relying on the obligation without notice of compromise. Compromise means basically we make an agreement where we agree to take a lesser amount in full settlement. May enforce the original obligation against such partner. Can he compel A to pay 10 lakh? Yes, he can compel A to pay 10 lakh. I hope it's clear to everyone. Financial disclosures, books of accounts, I should maintain proper books of accounts. How can I say that it's proper books of accounts if it is maintained on cash or accrual basis and double entry system? In case of company, it always has to be on the accrual basis. Here it can be cash or accrual basis. It is kept at the registered office and it should be audited. Statement of accounts and solvency shall be prepared within 6 months from the end of the financial year, shall be signed by the designated partner, and it will be filed with the registrar, and obviously it has to be audited. Annual return has to be filed within 60 days from the end of the financial year with the ROC, the registrar. Only this much is given, so I don't even want to go into the detail. What is annual return? What are the contents? Not even needed. Can these documents which are filed with the ROC, can we say it's with the registrar, can we say it's a public document? Yes. And can we say it is open for inspection? Yes. So, incorporation document, name of partner, statement of accounts and solvency and annual return, or any changes in the name of the partner, everything is filed with the registrar and it shall be open for inspection. Something, if you remember, doctrine of constructive notice, something like that only, right? I mean, it's open to the public. You can actually go and read it. It's available for inspection. If the registrar needs any information, feels that some information is lacking, it's not given, whatever, needs any information, can he ask the LLP for the information? Yes. From whom? He can ask any partner, whether past partner or present partner. That means if I'm no longer a partner but I was a partner and he wants an information of that period, he can ask me also. Can he ask it from the employee? Yes. Can he ask it from the designated partner? Yes. If you have not, if he asks you, please give me this information, and you don't give the information, or you give information which is not sufficient, okay, you don't give the information or you give information which is not sufficient, he can actually give you a notice of summon. That is, he can tell you, come and present yourself at this place at this time. So, the registrar may ask for any information from any present or former means past partner, designated partner or employee, to answer any question or make any declaration or supply any details or particulars in writing. If the person does not answer or does not make declaration or give particulars, or registrar is not satisfied with his reply, he shall have the power to summon him, either before him or an inspector or any public officer whom the registrar may designate. He can say, please come and present yourself at this place at this time in front of this person. If you fail to come to the summons without any lawful excuse, then 2,000 to 25,000. I hope it's clear to everyone. Yes, compounding of offence. First of all, let me tell you what exactly is compounding of offence. I have committed an offence. I know I will be punished for that, and a case will go on. I'm like, I know I have to pay the penalty. I know I have done this offence, I have to pay the penalty. If the case will go on, it will go on for months and months. Why to waste time of my and the court? Let me just go and tell them that, okay, I will pay the money, please don't take the case. So this is basically compounding. Compounding is either you have done an offence which is punishable by fine or imprisonment, and you settle it with fine, or instead of going through a lengthy procedure of prosecution, you just say, settle it, I agree, I have committed this offence, I agree, I have to pay, tell me what I have to pay, I'll pay it to you. So when an offence is punishable, you have committed an offence, you have to pay a penalty, and you are like, instead of paying, instead of going to the court, going for all the cases, let me just go and tell, I have done it, please tell me, I will pay the fine without the prosecution. This is compounding. Who can do it? Regional director can do it, or any other officer as authorized by the central government, but he should not be below the post of the regional director, below the rank of the regional director. Which offences? Here only which is punishable with fine. When can you make an application for compounding? Before the case is filed or even during the pendency of the case? Once the case is decided, then what compounding? They have already declared. Compounding is done that instead of going to the court, the lengthy procedure, let me just pay. No, I have to pay anyway. So it can be done when? Before or after the institution of any, during the pendency. If you have applied for compounding before any case is filed, then no case will be taken against you. Or if after the case is filed you have applied for compounding, then the offender will be discharged by the court. That, okay, we are discharging you. Now compounding you have applied, compounding will be done. How is the compounding done? We basically collect from you a sum which may extend to the amount of the maximum fine provided, but shall not be lower than the minimum amount provided for the offence. That means what? You have committed an offence which is punishable by 10,000, can go up to 5 lakh. So for compounding, they can tell you, deposit 3 lakh rupees and we will do the compounding. Right? Right. So this will be so it will, they cannot tell you to pay less than 10,000, they cannot ask for more than 5 lakh, they will ask you something in between. You have to apply to the registrar. Registrar will forward this application along with his comments to the regional director or any officer authorized by the central government. Once they give you the authority to compound, order of compounding is given, you will give a notice to the registrar within 7 days that yes, I have got the consent for compounding. This is compounding of offence. Just remember this much. If you remember, it covers everything. In book, if you will see, it's like too many things are there. Okay. Can a partner transfer his rights? Let us say I want to transfer 20% of my share to Mr. A. Can I do that? Yes. This is known as what? Transfer. Now two things will happen. First, does it result in the dissolution of LLP? No. So assignment or transfer. Basically assignment or transfer means what? I'm selling off my part or whole of my share to someone else, or transferring, gifting, anything. Does not result in the dissolution or winding up. Can A go and participate in the business? No. Can A ask for accounts? No. So, does not entitle the transferee or assignee to participate in the business or access information. Clear? Can a partnership firm convert into an LLP? Yes. Can a company convert? Yes. A private company or an unlisted public company? Ma'am, listed? No. When your shares are listed at the stock exchange, LLP shares, first LLP does not issue shares. Second, LLP ka shares are not listed at the stock exchange. So, obviously, listed LLPs, a listed company cannot convert into LLPs. So, actually, LLP, basically we have 82 sections, of which section number 82 is now removed, it's deleted, and 4 schedules. Schedule 1 tells you the rights and liabilities. Schedule 2 tells you about conversion of firm to LLP. Schedule 3 tells you about conversion of private company to LLP. Schedule 4 tells you about conversion of unlisted public company to LLP. Once you have converted, as per whatever is given in the schedule, once you have converted, within 15 days of conversion, you should give a notice to your old registrar. That is, let's say if you are a partnership firm, you should give a notice to the registrar of firm that I am no longer a firm, I am now an LLP. If you are registered as a company, you should give a notice to the registrar of companies that look, I am no longer a company, now I have converted into a partnership, into an LLP. You have to give this notice within 15 days. Give a notice to the registrar with which it was registered about the conversion. The partners of the firm or the members of the company will now be partners of the LLP. What is the effect of conversion? First, there is an LLP. All the assets of the partnership firm will go to the LLP. All the assets of the company will go to the LLP. Now, you don't get only the rights, even the obligations. So, all the obligations also will vest with the LLP, and the firm or the company is now considered as dissolved. The firm or company shall be deemed to be dissolved. I hope this is clear to everyone. Now we are almost reaching the end of this chapter. So moving on to the next one. Compromise or arrangement. Basically, please understand, compromise is something which happens between the LLP and its creditors. Arrangement is something which happens between the LLP and the partners. So basically, compromise is the creditors have to receive 10 lakh from the LLP. We make a settlement that instead of 10 lakh, we'll pay you 7 lakh in full settlement. That's compromise. Arrangement is internal reconstruction of the LLP. So, excuse me. Compromise or arrangement can take place between whom? If you look into the book again, it's huge. If you remember this chart, you literally cover everything. It can happen between the LLP and the creditors or the LLP and the partners. For this, you have to make an application to whom? Obviously to the tribunal, right? When you make an application to the tribunal, he will order a meeting. Now, who can make an application? The LLP can make an application, or the creditors can make an application, or the partners can make an application, or if the LLP is being wound up, the liquidators can make an application to the tribunal. The tribunal will order a meeting of the partners or the creditors, as the case may be, and we need the consent of 3/4 majority. Of whom? Of the creditor or the partner. We need 3/4 majority of the creditor or the partner that yes, I am giving my consent to the compromise or arrangement. And we also need the approval of the tribunal. Now, you know what? Unless the tribunal is satisfied that you have given all the material facts, that means your financial position that you have shown is absolutely correct, and you have already given all the declarations about whatever case is going on against you. You have given clear, plain, you have given all the information. If the tribunal is satisfied, you have given all the information, then the tribunal will give the approval that yes, go and get your compromise or arrangement. Correct? Now you have to, when this order of compromise or arrangement is given, you should file it with the registrar within 30 days that we have been sanctioned this order of compromise or arrangement. When you are carrying out with your compromise, the tribunal also has a right to supervise the procedure. So whenever we are doing a compromise or an arrangement, we have decided this is the procedure we will follow to do it. So the tribunal can supervise it. The tribunal can also, after the starting of the procedure, he can also modify that. No, I think this is not okay, let's do this. Or if they feel that compromise or arrangement will not work, the tribunal can even order winding up of the LLP. Right? So the tribunal can carry out, modify or order winding up if it cannot be carried out. Now, reconstruction or amalgamation. Internal reconstruction, I told you, amalgamation means amalgamate with another LLP. Please remember, the first part is the same. This procedure will happen. After that only this will come. This portion will happen and only after that this will come. So whenever the LLP has proposed a compromise or arrangement, or they have decided to transfer a part or whole of their undertaking, business unit, or property or liability to another LLP, they have to apply to the tribunal. The tribunal may sanction the compromise or arrangement or may order that the whole or part of the undertaking of the transferor LLP can be given to the new LLP, the other LLP, sorry, not new, to the transferee LLP. Basically, LLP 1 wants to transfer its undertaking to LLP 2. So LLP 1 is the transferor LLP, LLP 2 is the transferee. LLP 2 will get the undertaking of LLP 1. So LLP 1 is giving transferor, LLP 2 is getting transferee. It will say that whatever legal proceedings was going on against LLP 1 will now go on against LLP 2. That means continuation of legal proceedings of transferor against the transferee LLP. What will happen to LLP 1? It is actually dissolved without even winding up. This LLP 1 is dissolved. We don't have to. So basically, whenever you go for amalgamation is basically one LLP is dissolved. Without the procedure of winding up, the LLP is dissolved. When LLP 1 amalgamates with LLP 2, LLP 1's existence is gone. It is over, khatam, end. But did we go for winding up? No. So basically, amalgamation is a procedure of winding up without going through the procedure of winding up. And those who did not agree, see, we needed the consent of 3/4. So some may not have agreed. So those who have not agreed, what provisions we have given. So we will say, please give their money back or whatever. So what provision has been made for that? Or it can pass any other incidental orders. But before it passes any order, tribunal will make sure that the business of they will get a report from the registrar. And this report should state that they are not doing any work which is against the public interest. If this report states, reports of the registrar states that the LLP has not done anything which is against the interest of the public or interest of partners, only then the order for amalgamation will be given. Or if it is going into winding up, then the report will be given by the official liquidators. What report? That the affairs are not conducted in a fraudulent manner. Because it should not be like, I have done wrong things and now I am saying let's go for amalgamation, so to cover up the wrong things. No. So tribunal will pass an order only when it is sure that you have not done anything wrong. And within 30 days of the order, you will file a copy of the order with the registrar. The last topic, winding up. Tribunal. LLP can voluntarily wind up without the order of the tribunal, or they can get an order from the tribunal to wind up. What are the cases where the tribunal may order for the winding up? First, let's say there are 10 partners. The 10 of them decided, let's go to the tribunal and ask the tribunal only to help us wind up, to pass an order for winding up. So then they go to the tribunal, they approach. They decided to wind up, but they wanted tribunal's order. So the tribunal passes an order that okay, go for winding up. Or if my number of partners have gone down below 2 and I am carrying my business for more than 6 months, can tribunal wind up? Yes. I have done anything which is against the interest of the country or the state. Enemy company. Government has declared no one should make a contract with this company, enemy company. I go and make contract with them only. Oh, yo, wind up. For 5 consecutive, if you remember, statement of accounts and solvency, and there was another document, annual return, have to be filed with the ROC, correct or not? If for 5 consecutive, but this is consecutive, if for 5 consecutive years you don't file it, LLP will be dissolved. And the last one, any just and equitable grounds. Any other grounds which, not these 4, this is there, any other grounds which the ROC feels, the tribunal feels that the LLP should be wound up. For example, we had just done one point here. Order winding up if they feel the compromise or arrangement cannot be carried on. With this, we are done with LLP. I hope this video was helpful to you all. Keep studying, keep learning. It's just a month for your exams now. I'm not counting January. Happy learning and stay motivated.